Okay. Good afternoon, everyone. Do we have an echo?
A bit of an echo.
Maybe do you want to use this one instead? I'm sorry. I don't know why that's happening. It didn't happen yesterday when we tested it.
Well, I'll speak loudly. So
Yeah.
more than one mic here. I'll
Yeah.
stand over here. I'm here
it's
to
fine now.
the Deschutes County's Community Development Director, and I want to thank all of you here in person and those that are participating remotely for attending today's open house on the rural accessory dwelling unit. Opportunities that are going to be made available tomorrow when the code comes into effect. I want to acknowledge that all of you, and some of you maybe directly or informally, all of you played a role in compelling the state legislature with the passage of Senate Bill 391 and ultimately the Board of County Commissioners for adopting regulations that allow for rural ADUs in certain areas of rural Deschutes County. We're one of the first counties to adopt these regulations that create a program that can allow for rural accessory dwelling units. So before I turn it over to the Community Development Department staff, I just want to recognize our staff who will introduce themselves momentarily for hosting this open house, but as importantly, preparing materials. We have a robust website that I'm sure some of you have already dabbled with. This PowerPoint will highlight much of that information, but it was all done to allow all of you and your friends and neighbors and residents going forward to help make informed decisions about taking advantage of this program. So we want to make the best use of your time this afternoon. We set aside an hour. I know we have a robust PowerPoint and a panel here that offers certain expertise. So I will turn it over to them. But thank you all for being here this afternoon. It's really important that we get this information out to you and ensure again that all of you can make informed decisions going forward. So I'll turn it over to Caroline House, a senior planner.
Great. Yeah. Echoing Peter's sentiment. Thank you all for being here. We're really excited to share this information with you. My name is Caroline House, and I'm a senior planner with the planning division. So I'm an expert on all the zoning regulations, and that's what I'll be covering today and responding to during the Q&A session.
Good afternoon. My name's Amy Doherty. I'm a plans examiner with the building department, and I'll be going over the requirements for building review that include R327 and wildfire hazard mitigation.
Hi, I'm Todd Cleveland. I'm the on-site wastewater manager in the community development department. That's septic systems. So I'm here to talk about septic systems.
Good afternoon. I'm administrative manager Angie Havner, and I'll be here to talk about the permitting process.
Good afternoon. My name is Jennifer Lawrence. I'm an administrative supervisor, and I will be talking about the permit process.
And I'm Kyle Collins, also with the planning division, also the one that helped lead adoption of this bill. So I've been the behind the scenes person. If you've talked to anybody about this over the last year, it was probably me.
So I think we'll go ahead and get started on the PowerPoint. So for today, we have about a 20-minute presentation. And then if you walked into the room, you may have seen a little small sheet of paper with a QR code on that. That's how we're going to be conducting the Q&A session. So if you have a smartphone, you can scan that with your phone. And I'll go over that more when we get to that part. But the presentation should take about 20 minutes. We're going to start with first reviewing the zoning requirements. Then we'll go over the septic requirements. Then discuss the wildfire hazard mitigation standards, or the R327 standards. That's the fire hardening requirements for ADUs. And then we'll have staff available to talk about the permitting process. And then we'll start that Q&A session that we discussed. And I do want to acknowledge as well that a lot of you submitted comments to us in advance, and we have collected those and we'll include those. We have a lot of questions already, so we may not be able to get to everything today, but we will work to either post answers to those questions on our website, or we'll respond to you separately. So kicking off with the ADU zoning requirements, for a little background, Peter touched on this, but state law just recently changed to allow for ADUs in rural parts of the state of Oregon. And so those bills were passed in 2021 and 2023. After that, the county, Kyle, as the planning representative, has taken those state laws and adopted them into our local codes. And a lot of the questions we've been getting are regarding variances or exceptions. And I have to highlight at the onset that we can't grant a variance to state law. We have to follow the state law. So we'll go over that in our presentation in the next slides. And permits are going to be required for accessory dwelling units. And you'll likely have a planning permit, a septic or 2 septic permits potentially, as well as building permits and some other kind of supplemental smaller permits.
Yeah, just to cover some background here. So what is an accessory dwelling unit or an ADU? It is a secondary dwelling unit that's going to be used in connection or conjunction with your primary dwelling on site. So some other common names that we hear relatively often over at the CDD counter, in-law suites or mother-in-law suites, granny flats, any of those broadly just mean the same as an accessory dwelling unit. So regardless of what language you're using, we're all talking about the same thing here today. You also might be aware that each of our 4 incorporated cities in Deschutes County have their own standards regarding ADUs. So whether you're in the city of Bend or the city of Redmond, they actually have their own program with different rules that apply. So if you have specific questions regarding how to develop an ADU within each of those cities, you'll need to reach out to each of their community development departments respectively. But everything that we're going to talk about here tonight is just related to the unincorporated areas of Deschutes County.
So under the state law changes, there's only 5 zones in Deschutes County that qualify for an ADU under our zoning allowances. So the first one is the rural residential zone, or RR10. Then we have the multiple use agricultural zone, or MUA10. Then we have the urban area reserve, UAR10. We have the suburban low density residential zone. And lastly, the West Side Transect Zone. And I want to highlight that these zones are not located in the unincorporated communities of Tumalo, Terrebonne, Sun River, or Black Butte Ranch. So these are in the more rural areas of the county. And the next question you're probably asking is, well, how do I find out what my zoning is? And so the county has an online property information website, has lots of great information, including the zoning designations for properties in Deschutes County. So the website's on the screen, but it's dial.deschutes.org. And when you go to the site, it's going to default to the taxation and assessment information, but there's a navigation menu on the left-hand side, and you're going to go down to the development section, and this is circled on the screen here in red. And you'll select summary. And under that, once you click that, I should say, you will see the zoning designation in the center part of the screen. And this is a great resource again for zoning, but you also can find permit information here, historical development documents, and other great information if you're looking to develop your property.
Awesome. So next, we're going to talk about some of the base level zoning standards that we have for ADUs. So the first and foremost is that you have to have a primary single family dwelling established on your property in order to qualify for an ADU. However, if you have a vacant property, there is an opportunity to develop that primary dwelling in an ADU simultaneously if you elect to move forward with that type of development plan. The next thing that you'll need to be aware of is that properties, in order to qualify, have to have at least 2 acres or more in most areas of the county. There's one very big exception to that, which is the southern portion of Deschutes County. You'll actually need 5 acres or more in order to qualify for an accessory dwelling unit. That has to do with some groundwater considerations, which I'll cover here. So again, that 2-acre minimum standard comes directly from state law, the Senate Bill 391 that we've referenced a few times here. The 5-acre minimum standard was elected as a choice by the Deschutes County Board of Commissioners, and it's specifically related to our South County groundwater protection area. You can see a copy of that here, a map of that. It generally covers the area from Sun River south to the Klamath County border, and that area is intended to preserve drinking water in a sensitive groundwater area. So there are some nitrogen reducing system requirements that might be mandated for certain type of septic systems. But broadly, the goal with those larger property sizes is to protect that drinking water resource. Todd Cleveland, our on-site wastewater, can talk more about that a little bit later in the presentation.
So continuing on with some more of the ADU zoning standards, one of the big requirements that comes from the state law is there's a 900 square foot limitation on the usable floor area. And usable floor area includes all areas of the structure except garages, porches, and decks. So everything gets counted in that 900 square feet except, again, garage spaces, porches, or decks. And then also coming from the state law, the ADU has to be located within 100 feet of the primary dwelling. And there's really two ways the code has split out how to take this measurement. The first is for new construction. It's measured from the wall of the primary dwelling to the closest point of the usable floor area. For converting an existing structure, you actually get a little bit more distance potentially. It's measured from the closest wall of the primary dwelling to any point of the existing structure. So that could be a garage space and an accessory structure. It could be porch, deck. All of those things would be counted if it's an existing structure that you're converting to an ADU.
Next thing we'll talk about is we have some additional wildfire mitigation standards that you may or may not be familiar with. These, again, are all coming from state law. They're going to break into three broad categories. The first is that any accessory dwelling units that are constructed have to be built out of fire-hardened materials. And those materials are coming directly from what's described as R327 of the Oregon Residential Specialty Code. That's going to include any new ADU construction or conversion of existing structures. So if you have an existing structure that wasn't previously built with these standards, you'll need to take into account that that conversion process will need to include upgrades to all those types of materials. The next thing, there are special driveway access requirements. We have a list of requirements in the code currently of how driveways need to be constructed, dimensional standards, things of that nature. As a secondary option, you do have the possibility of discussing this with your local fire protection district to have some other type of development or access plan. And then finally, there are vegetation management or fire break standards that are going to be required around the ADU. So you can think about trimming flammable vegetation and broadly a pattern away from the ADU. Again, you would also have the option of discussing alternative vegetation management strategies with your local fire protection district if you don't want to go through with what's listed in the code currently.
And I also want to highlight some of the utility requirements that are going to have to be established prior to applying for your zoning permit. So the first is you'll have to be in a fire protection district. That's from state law. There's no variance to that. Additionally, there's a requirement to obtain a on-site or septic site evaluation prior to applying, or if you're in a sewer district, you'll have to get a will serve letter from your sewer provider. And then for water, if you're again in a water district, you'll have to get a will serve letter. And if you're on a well, you'll need to contact the local water master. That's who works for the Oregon Water Resources Department, and confirm what your requirements are for a residential exempt well and how that works with an ADU.
All right. And the last land use or zoning standards that we have here. So if you do elect to move forward with building an ADU on your property, you should be aware that from that point forward, neither your primary dwelling or the ADU itself can be used as short-term or vacation rentals. That's pretty steadfast. A lot of it comes from state law. The Board of County Commissioners also elected to include that prohibition on the primary dwelling as a part of our rules that we've been talking about here today. The next is that certain zones in the property would have qualified for accessory uses that you might be aware of called guest houses. Those are not the same as accessory dwelling units, although they do share similar characteristics. But if you already have an approved guest house that meets all the relevant land use standards for Deschutes County, you can't qualify for an ADU if you already have one of those uses established, unless you elect to move forward and convert that guest house or similar use into an allowed accessory dwelling unit, again, provided it meets all the standards that we've discussed here tonight. And then finally, accessory dwelling units have to be standalone structures. They can't be attached to your primary dwelling. So you couldn't construct, for example, something that functions more like a duplex. This actually has to be a separate building that meets all the relevant requirements that we've talked about.
So just to kind of cover some of the details of the actual planning permitting process. So the It does require a permit, as I've mentioned. The review fee is $730. The review time is 30 days or less, but you'll have other permitting requirements, which Jen and Angie will cover just in terms of like the total time that you'll need to account for the full review process by the county. And we have an application form that basically walks through each of the zoning standards that we've covered in today's presentation, and hopefully helps lay out what your options are for how to meet each of those standards. And to submit your application, it's a little bit different than your building and septic permits, which go through the e-permitting system. Planning is not set up to receive applications like that. So you'll either have to email them to us, drop them off at the counter, or you could also mail them to us as an option.
So ADU septic requirements, that's on-site wastewater systems or septic systems in the rural county. If you're on sewer, if you have sewer, that's great, but you'll need to talk to the sanitary district or sewer authority that would address that. Septic systems are fundamental infrastructure. So when you're adding a new dwelling, this is a second dwelling, the ADU is a new dwelling. There are minimum sizing criteria for dwellings. We want to start with a review of the property to look at site evaluation, test pits, see what we can do there. We're going to evaluate the existing system as well, what it may need to be modified to meet minimum standards if we can approve it. So the purpose of that is it's going to make sure that system's sized, or the new system is sized to serve the new dwelling. We're not going to impact the existing dwelling system, or we can expand that system. So typically you're going to need the site evaluation process and a construction permit of some kind, because the existing infrastructure was only sized to serve one dwelling. That's the only thing we've ever evaluated that property for in the rural community. Everything's approved for one dwelling. Now we're going to have two. So one of the things that we want you to do is to start that process as soon as you can. It's really the first step. It's much like new development. When you're developing a vacant property, one of the first things you want to do is to do a site evaluation. So the earlier you start that, you get this report, it's going to give you your options. So what is a site evaluation? So in this case, we're going to want to see where the existing infrastructure is, test pits for soils. We're going to evaluate those test holes. We want to look at what's available. We want to understand where this system's going to go. We want to understand the space, what sizing criteria are going to be needed. So we know that it's 300 gallons a day for an ADU. The primary dwelling sized at 450 gallons per day. So that would be, if you were going to combine those together, that's 750 gallon per day system. So it's a significant increase beyond what's been permitted on that property historically. If we did that as a combined system, you know, that's going to be a 750 gallon per day system. If it's an alternative system, that may require a design professional. So one of the critical components that we're going to be evaluating when we're looking at the property is not only can we serve what we can do today and get it installed, but we've got to make sure that we can replace that system. We have sufficient area to serve both residences going forward into the future. Septic systems are a temporary setup. They don't last forever. So we always have to have room for an initial and replacement system. Very critical.
Okay, so now we'll move into the wildfire hazard mitigation portion. We'll talk about the requirements. R327, Kyle touched on it briefly, is referenced to this specific section in Chapter 3 of the Oregon Residential Specialty Code. Wildfire hazard mitigation is commonly referred to as home hardening and or fire hardening. And it's meant to address the most vulnerable parts of a home. And specifically, we're talking about an additional dwelling unit, as currently this section only applies to ADUs. The intent is to increase the structure's resistance to heat, flames, and airborne embers, and to slow a fire down, allowing more time and opportunity for emergency services to respond. So what it means that there are new requirements for exterior building elements, such as choosing siding materials like hardy plank over T111 and using attic ventilation devices that are designed to different standards that minimize and prevent ember intrusions. It also means that there are now new requirements to use construction materials that are specific to this code section and largely defined as heavy timber, ignition resistant material, and non-combustible material. We did provide a complete list of the building elements subject to this requirement. If you're here today, there is a fire hardening handout. It is also available on the website. So these key definitions, oops. We'll talk about the key definitions that are referenced in the code, starting with heavy timber. These are described and defined as sawn lumber or glue laminated wood with a minimum nominal dimension of 4 inches. Ignition resistant materials. These are going to be tested and labeled materials that resist ignition or sustained burning when exposed to embers and small flames from a wildfire. An example would be fire retardant treated wood, something you might use for decking. And lastly, non-combustible materials. These are materials that will not ignite or burn. So some of the examples are on the slide there. There's concrete, steel, masonry, and multi-layered glass. So the key takeaways regarding implementation are that these new requirements apply to both newly constructed ADUs as well as existing structures converted to ADUs. And that submission of construction plans for building permit review need to include details and notes that demonstrate full compliance with R327. So again, if you'd like more information, a copy of the fire hardening handout can be found on the Deschutes County website. We have a section devoted to the ADUs. It's www.deschutes.org/ADU. And then you can find the building code online. The Oregon Residential Specialty Code is found on the Building Code Division's website. And that's at www.oregon.gov/BCD.
So I am here to talk about the permitting process. You have had a lot of information thrown at you. There's a lot of moving components to this. And as you've heard, it's very property specific. So I would encourage you all, as you're thinking about ADUs on your property or multiple properties, to utilize resources. As community development is adjacent here, right across the street. We have staff on site in person that can meet with you and then encourage you to do pre-application meetings as well. But on site daily, we have planners that can meet with you, permit techs, on-site staff, building department staff. There's a lot to process here. So I'm going to attempt to kind of put a little bow on it for you. But keep in mind, this is a very generic summary and very specific applications may apply to your individual property. As Todd noted, the first step for your development requirements is a site evaluation on your property. A site evaluation is where you dig the test pits. They're typically 4 by 4 by 5 feet deep at an angle. The sanitarians will walk into the pits, test the soil types. Typically, we see 5 of those kind of in a dye space. These are, I do want to note, weather permitting. This is a type of this season, the weather is changing, the ground is frozen. Typically, the review time is 3 to 4 weeks. In this time of year, it's going to be longer. The ground cannot be frozen in order to test those soils. You can apply for this electronically through the Oregon e-permitting. Planning approval will be through our planning division. This is something that you will apply for in person by email or mail, as Carolyn noted. The review time for this is 30 days. Your septic installation permit, this will be the second permit that you need through our on-site wastewater division, as long as your site evaluation is approved. And this is a secondary permit that is for the actual installation of the approval. The review time for this is 10 days, and this is an application through our Oregon e-permitting site. Building permits through our building safety division, they are also applied for through Oregon e-permitting. Review time is approximately 8 to 10 weeks. This also is very site specific if there's additional planning requirements for landscape management, wetlands, those type of things. So these are very generic timelines, but pretty close to ballpark. In addition to that, the driveway access permit may be applicable to you. This is a permit that community development does on behalf of the road department. The review time for this is 2 to 3 weeks, applied for through Oregon e-permitting. This one can be a little tricky dependent on the lot. If you are on a corner lot, each ADU is going to be required to have its own address. It'll have an individual address. This will be given to emergency responders. If you're on a corner lot, that address then would be designated to the road designation based on access. So this can be a little bit tricky. The road department is allowing still 2 driveway accesses. So if you currently have 2 approved, you will not be able to get a third for the ADU. Planning, septic, building, and driveway permits can run concurrently. So you can apply for those at the same time. We will process those for efficiency together. And then again, I encourage you to come in to utilize the resources across the street, email us, call us for individual questions. It's a lot of information to process.
And I'm going to note one thing just on that last point. The septic site evaluation has to be done before all of the other permits. So that's the only one that cannot be concurrent.
Yeah.
So that's why the timing of that is so important to start that early, because you can't start any of the other permits until the site evaluation is approved and it's determined what's needed for the septic.
Especially this time of year.
Yeah.
With the ground being frozen, that could delay your whole project. Thank you.
All right, so as far as fees, we put together an example. The example we're using is a 900 square foot ADU. And through the site evaluation, it was determined that it would be a new ATT septic system. So step 1 with the site evaluation, all of these fees are current as of now. However, they are subject to change annually. So septic site evaluation is $1,005. Planning permit, $730. Septic installation permit for the new system, $2,168. Building permits total for the dwelling would be $5,000. Driveway access permit, if applicable, $8,150. And then transportation system development charges, those are currently half of what a primary dwelling SDC is. That's $2,269. That can be deferred until final inspection prior to certificate of occupancy. That would be required. So for this example, permit costs are approximately $11,500. I would like to add, though, that those properties that are serviced by the city, so West Side Transect, for instance, those will have a city Bend Park and Rec SDC. Those currently for ADUs is $4,700 in addition to that. So.
And one thing, Jen, when we were meeting to talk about this presentation, this also does not include if you have to go through a landscape management review, as Angie just mentioned. So if you have other overlay zones, there could be other fees. So this is just an example. And anytime you're interested in getting a kind of estimate, you'll want to contact us and we can give you better numbers based on your specific proposal. So we're going to transition to our moderated Q&A. So if you haven't already submitted a question, you can do that now. If you have a smartphone, you can scan the monitors, or if you got the little handout, you can do that at your seat. And Kyle's also, again, taken the questions that people have submitted in advance, and some of those will be worked into this little session now.
Oh, we've got a lot of good ones. I'll also reference anyone that happens to be watching this online via Zoom. You're welcome to submit those questions as well, and we'll try to get through as many of these as possible. If you have more specific questions related to, let's say, your individual property or something that's not broadly applicable to the group, we will have many members of staff here after the presentation is over and after we're done with the moderated Q&A. So you can walk up to us, ask us some questions. We may not be able to give you an exact answer during that time, but we can certainly give you resources and contact information to set up a meeting at some point in the future. So first question, Caroline hit on this a little bit at the beginning, but I thought it was bears repeating, which is, are there any exemptions or variances available for any of the standards that we've talked about here tonight? As Caroline mentioned earlier, all of these standards come directly from state law. And given the structure of Oregon's state land use system, we cannot grant variances or exemptions to any of these standards. So that includes the 2-acre minimum property size standards, the 900 square foot usable floor area standards. Any of the standards that we've talked about, generally, there are no exemptions or variances available until such time as state law were to change. At that point, we could potentially incorporate something, but as the program stands today, we cannot grant those. Second question that we have is, if an existing septic system isn't adequate for adding an ADU, is it necessary to expand the system or improve the existing system, or will we have to add an entirely new second system?
So as I said, that's why we're doing a site evaluation. We're going to give you options to what it would take to add to that system, modify it, or if you wanted to put a separate system in, this is going to give you those choices. One of the issues with trying to add on to an existing system, especially one that let's say it's been in use for 15, 20 years, there's wastewater in that system. It's set at an existing elevation. Trying to tie into that system is potentially dangerous, damaging to that system, and you expose people to wastewater. So it creates a health hazard. Oftentimes that's not the best option. So what I'm finding is that people are looking at these and thinking about doing a separate system. So it's either choice is the option at this time.
Next question is, how will the 100-foot separation distance rule be measured? We covered this a little bit, but Caroline, I don't know if you want to.
Yeah, I think, again, it's just really, you want to split it into 2 categories: new construction and converting an existing structure. New construction, primary wall of the primary dwelling to the usable floor area, conversion of an existing structure, wall of the primary dwelling to any point of that existing structure is 100 feet. And
Including like a deck or something?
Yep.
Okay.
Including decks, carports, as long as there's a structure within that distance or part of that structure is within that distance, that meets that standard.
It's set by the state or the Deschutes County. That distance.
Kyle, I know the first one was certainly set by the state, but I think the board
Correct.
interpreted the second bit. Sorry.
So there's two answers to that question. The 100-foot rule itself comes directly from state law. So the number itself comes from state law. How it's measured was an interpretation and a decision made by the Deschutes County Board of Commissioners. So they've elected to highlight those 2 possible routes for new construction, which is the more stringent standard. And then for pre-existing structures, there's a little bit of leeway associated with not measuring from usable floor area portions of whatever the approved ADU is. Next question is, will a separate address be needed for an ADU?
Yes.
And I think just to add on, so that will, at a minimum, it will be issued before you get your building permit for the accessory dwelling unit. We have an addressing coordinator at our department. If you email addressing@deschutes.org, she's going to look at all of the rules that go into that and coordinate with emergency services and the road department to get that address assigned.
Sure. Here's a good one. Are there any specific height limitations for ADUs beyond our other standards?
There are no additional height limitations, but the standard zoning height restrictions will apply. In most zones, I want to think in all 3 of these zones, I'm pretty sure 30 feet is the height limit for all structures. There's potential for overlay zones where we maybe measure that a little differently, but 30 feet is the rule of thumb on your property. You know, this is a great example of where you'll want to come in and talk to us if you have slope on your property, or if you're adjacent to a road or one of our designated scenic rivers. We may measure that differently. So come in and talk to us before you start developing your plans. One of the things that I meant to emphasize earlier is that we're really encouraging applicants to come in for pre-application meetings. These are free meetings where we'll have staff from planning, on-site wastewater or septic, coordinated services, and the building division to talk about your property specifically, give you direct feedback. If you, you'll have to have a site plan for this. So it will be a meeting where we can really make sure that we've done a good job communicating the requirements. And if you have specific issues with trying to get to an approval, we can talk about maybe how to resolve those and give you advice.
Okay. Next question is, will a separate electric meter be needed for an accessory dwelling unit? And what is the process for acquiring that?
So the answer is that no, it is not required. So then there wouldn't necessarily be a process for acquiring one.
Awesome. Here's a good one. Are there any exceptions for allowing accessory dwelling units on exclusive farm use zone properties? Short answer to this is accessory dwelling units are not allowed on EFU or exclusive farm use zone properties. Again, resource zones, our exclusive farm uses, and our forest use zones are all governed by state law. And Senate Bill 391, the program that we're following here today that allows accessory dwelling units, did not include those resource zone properties as a part of this bill. And so if you have an EFU property, unfortunately, this time, you're not eligible for construction of an accessory dwelling unit.
And I'll add though, there may be other allowances for what are called like hardship dwellings. So what I recommend doing is contacting us for other dwelling options. And we can give you that information. And that's true for not just EFU, but forest use, other zones in Tumalo, Terrebonne. We may be able to go over different options with you, but Kyle is absolutely correct. Accessory dwelling units, which is a specific use category, are not allowed in those zones.
All right, I've got another one for Todd. Why will an ADU be considered its own dwelling and have to meet different standards that differ from adding something to a bathroom in a barn or shop building?
Because a bathroom in a barn is accessory to the existing dwelling. This is a separate dwelling unit, and Oregon administrative rules for dwellings have minimum sizing criteria. And we're allowing this one as a subordinate smaller dwelling by code. It's only 2 bedrooms. The table 2 in DEQ rules allows for 300 gallons per day. That's the minimum sizing. That's for a dwelling. This has laundry facilities, cooking facilities, cleaning facilities. It's a full house. So it's small, but it is a full dwelling. It's not just a bathroom in the shop. Completely different use.
So more people, 2 families.
Yeah, you would have a separate family living there. So they're doing everything that all families do. And so, they're washing laundry. And one of the things that's going to happen. So, yeah, lots of use. So there's potential, and there's no way to control how many people are in that house, right? So you've got 2 bedrooms. There's assumptions based on those 300 gallons per day. So that's sized to handle the maximum, right? That's the peak flow. That's the design flow. That's what we're obligated to follow. That doesn't necessarily mean that everybody uses the same thing. If we were to combine systems together, there could be potential for very high surge flows. So think about it. Most people, they get up, they have kids, they go to school, they go to work. There's a lot of use in the morning. They're gone all day. They come home, make dinner, do laundry, do dishes, take baths. So there's both households may be having these kinds of effects on a system. So you have a huge amount of flow in the morning and a huge amount of flow in the evening. If it's not sized accordingly, what that means is that you've got sewage all over the place. So that's what we're trying to avoid.
Thanks, Todd. In reference to the 900 square foot usable floor area standard, how will that be measured?
So again, usable floor area includes all areas except garages, carports, and decks. And we're considering garages anywhere you can drive a vehicle. So if you have storage rooms in your garage, that storage room is going to count towards your 900 square feet. So that's really important as you're developing your plans. I'm really encouraging prospective applicants to send us your draft floor plan before you do your whole plan set, just to make sure what you think is the usable floor area matches how it's going to be evaluated when you come in for the full review. You can have, say, a detached small accessory shed because maybe your tenant needs bikes or whoever's living there needs another small storage area that's detached. That's allowed. But if it's included in the garage area, that's going to be added to that usable floor area.
A follow-on question to that. Will accessory dwelling units be allowed their own detached garage spaces or any other type of storage components?
Yes, but to a limit. So generally, if you have a 2-car garage, something like that, that's fine. But if you come in for a 3,000 square foot garage, we're probably going to be asking you, is that really accessory to your dwelling, your ADU, or is that a whole new use? So we would want to talk to you more if you need a very large detached accessory space, but generally that's going to be allowed.
Awesome, thanks. Regarding the wildfire mitigation driveway access standards, as I pointed out in the presentation, there are a number of specific dimensional standards and weight standards that are written into the code. There was a question concerning how would that be certified by either the property owner or specifically the community development department. I can answer the first part of that question, which is if you are moving forward with a development plan and you intend to meet the standards as written into the code, we would require those to be evaluated by a professional engineer that's licensed in the state of Oregon. However, as I pointed out, there is an alternative path, which is if you talk to your local fire protection district and they approve a specific access plan that is less than the plan essentially that we have written into the code or the standards that we have written into the code, we would allow that with written authorization from that fire protection district. So those are the two paths that you have available to you regarding driveway access and wildfire mitigation. This is an interesting question. How would property taxes be handled? And are there any breakpoints depending on the square footage of an ADU?
We don't do assessment in our office, so you'll really want to go talk with the county assessor about that. They're right upstairs. I know their email is assessor@deschutes.org as well, but they'll need to be consulted to get confirmation on how to calculate that.
Is a separate driveway going to be required for an accessory dwelling unit?
No. No. They can use the existing.
Why is a lot of record verification going to be required for applying for an ADU?
I'll start out, but Kyle, I think you probably have more background on this, but one of the things that the county evaluates is how a property was created before we're authorizing new development. And we have to verify in certain circumstances that that was lawfully done. Most properties were created as part of a partition or subdivision approval, so this is a very easy checkoff. But in some cases, properties were created before the county had zoning rules. So that's what a lot of record verification review is a look back at the history of how a property was created. I'll let you speak to maybe like the background on how the board or why they elected to add this. But
yeah, absolutely. So in general, the goal is to not allow an increase in development in properties that may have been created unlawfully at some point in the past. So while Deschutes County Code does currently have some exemptions to allow the maintenance or replacement of existing structures on a piece of property, in general, we shy away from trying to allow an increase in the level of development on a property that we can't verify was created lawfully. As Caroline pointed out, most properties probably will not actually have to go through a formal verification, although we do have that option available if we don't know the creation history of your property. But a vast majority of particularly rural residential properties were created as a part of historic subdivisions, and it's relatively easy to just find that historic subdivision, locate your lot, and we can essentially immediately determine that your property was lawfully established, and you can move forward with, in this case, your ADU development. Let's see. What is the reason the state chose to use the 100-foot distance from the main dwelling? And can we talk about any restrictions related to renting the ADU? Those are two very different questions, but I can speak to at least the 100-foot distance from the main dwelling. It was in general intended to just limit the impact of development on rural properties in the state of Oregon. So ADUs, obviously, it's a hot topic. A lot of people want to develop these. And generally, the goal is to allow these, but minimize possible impacts on neighboring properties, additional impacts that might occur with rural infrastructure such as septic by clustering development as close as it could possibly be to whatever the primary dwelling is on site. In terms of the restrictions on renting an ADU, ADUs can be used as long-term rentals. So if you construct an ADU and you have a long-term rental, they want to rent it for a year, 6 months, whatever it happens to be, that will be allowed. There's nothing in the code that disallows that particular use. What is disallowed is ADU use as a vacation or short-term rental. And a vacation or short-term rental has 3 characteristics. It's not being used as a primary residence. Whoever's living in it already has a primary residence that's elsewhere on the property, and it's being rented for 45 days or less. If you meet all 3 of those characteristics, it qualifies as a vacation rental, and it can't be placed in either the ADU or the primary dwelling once you elect to construct an ADU on site.
Amy, do you know if
Why? Yeah, that one brings up a huge why. Why build an ADU that can't be rented out?
The entire goal was to meet some of the needs of our states and our community's housing crisis, and vacation rentals were seen as a conflict with that particular use, both at the state level and by the Deschutes County Board of Commissioners.
I was just going to ask, and Amy, I don't know if this is correct, but is there any restriction on if it's going to be a rental on who can do the work for construction, or is that something that doesn't apply here? Do you know what I'm speaking to?
Yes, there is some language in the building code which says that an owner can't do work on their own property if it's for sale, for rent, or for lease. So I might have to defer to Chris. Okay. Is there anything you want me to add to that, Krista? It's just electrical? Okay, so just when it comes to electrical.
How long does it typically take for septic site evaluation and or septic installation?
So the site evaluation, the current average turnaround somewhere around 3 to 4 weeks. Of course, I mean, maybe not current, because I was literally in pits this week that were frozen solid. So we couldn't actually evaluate the pits. The soil was frozen. So when snow starts or the ground's frozen, that's going to delay decisions because we can't do a proper site evaluation. And it really does depend on how hot the weather is, how wet it is, and how cold it is, right? So, and of course, South County gets a lot colder and wetter earlier, and so they tend to freeze the first. But so that's the normal turnaround time, and it could be longer. For issuing a permit, you're coming in with all of your plans and designs and going through planning and permitting at the same time, and typically we get to those permits within 10 days for septic issuance. Installation, the permits are good for 1 year from the date of issuance.
Angie, just to piggyback on that, on the last question, if they own their property, like if they hold title in a specific way, should they come by or contact the permit tech division? Because there are some restrictions about how title can be held for, isn't there something about,
Like it's a trust or.
yeah, like the LLCs?
So for construction, if you're wanting to be, as an owner, do the work yourself, there is restrictions on that. We have to be able to essentially shake your hand and see who's doing the work for accountability. And then who's going to be, if it's a rental, as Krista and Amy noted, as so the electrical part, if it's going to be rental within 2 years, you're not able to do that work yourself. We are seeing properties that are titled, the owners are LLCs, trusts, that type of thing. So we have to do some digging sometimes to see who's that actual listed owner, and it can be complicated that way. So, I think that's what you're referencing, right? The LLC and the trust.
Yeah, maybe I just was thinking, maybe if you have a question about the way you hold title on your property, you could check
Multiple
with
owners.
our department before you get too far into the process to make sure that if you're looking to do the work, that it's allowed.
Would the conversion of an existing structure to an ADU have the same building permit fee as new construction?
Sorry, I was still thinking about something. Can you say it again?
Sure. Would conversion of an existing structure to an ADU have the same building permit fee as new construction?
So new construction is based on state valuation per square footage that the state requires that we have, and we do calculations, and that gives us the valuation. The plans examiners do that during their review. A conversion would be value submitted by contractor or homeowner, and then plans examiners also evaluate that and adjust it as needed during their plan review.
Is a guest house the same as an ADU, and does it fall under the same set of policies as ADUs?
So no, a guest house is defined differently in our code. So a guest house cannot contain a kitchen or kitchenette and cannot be used as a rental generally. So that's different than how the ADU allowances are. Was there a second part to that question?
No,
No.
that was it.
So, yeah, that one's pretty straightforward. I do want to note too that guest houses require a conditional use permit in almost all circumstances, except some of the zones close to the city of Bend.
Just historically, we have seen a lot of permitted guest houses that people were hoping to someday convert into an ADU. And if you fit in that category, that would be a really good opportunity for a pre-application meeting to just evaluate what's currently there, what would qualify or wouldn't. There's a lot of complexities to that situation. Also, fire hardening construction comes into play, so that those cases are going to be complicated.
Great. Why are ADUs not allowed in our unincorporated communities such as Tumalo and Terrebonne?
You want to answer this one or?
Yeah, I can answer that question. So based on Senate Bill 391, that state standard we referred to many times here tonight, the only properties that are eligible for rural accessory dwelling units are rural residential exception areas. Our unincorporated communities actually fall into a completely different set of land uses. Those unincorporated communities, they're sort of one-off and unique. We have a few of them in Deschutes County, Tumalo and Terrebonne, Sun River, those being kind of the primary ones. They have their own set of land use rules that apply. And unfortunately, that state legislation doesn't bring those into the ADU development set of guidelines that we have here tonight. However, you might want to read into the code specifically. We can certainly help you over community development because there are certain development opportunities that might be available. However, I'll pass it to Todd because I know there are some septic considerations specifically in Tumalo and Terrebonne.
So the biggest issue with those communities is the lot size and or the soil conditions. We don't have space or ability to get septic capacity to serve additional dwellings. Oftentimes we struggle to serve one house on most of those properties. And for example, in Tumalo, many of those properties are smaller than would be allowed under minimum lot sizing requirements in DEQ rule because that laid law was platted 100 years ago. So,
That's very site specific too. I mean, we're not talking about a huge area like we consider Tumalo to be everything between us and Sister. You're talking about just Tumalo, right? Okay.
Yeah, so on this is something that most of you probably won't be able to find on your own, but there's actually a boundary. We have a zoning map that identifies where our unincorporated communities are located. So yeah, sometimes people say I live in Sun River, but they're not in Sun River where we're actually talking about. So I would say if you have a question about are you in Tumalo, Sun River, one of these areas, you can check the zoning section on Dial. That will answer it for you, or you can contact us and we're happy to look that up for you.
and for Terrebonne, they just created a sanitary district. They're going to create a sewer system in a certain area, and that will, once sewer is there, those properties will have the ability to do some of these things.
Yeah, and kind of building on this, so these zones, Tumalo and Terrebonne specifically, do allow for 2-family dwellings and duplexes, but generally septic has been the limitation. So that may change over, the time as sewer becomes available in those areas.
Awesome. I think we got time for a couple more here. One question is, will the wildfire mitigation rules that we've talked about here tonight change once the state wildfire hazard map is ultimately adopted? I can answer that question. So the way the rules are written, both related to the wildfire hazard map at the state level, as well as our local standards, there will be kind of a turning point. Once the maps themselves come online, Only those properties which fall into high hazard designations and/or wildland urban interface areas will be subject to these additional wildfire mitigation standards, specifically the fire hardening standards that Amy spoke to earlier, as well as defensible space and vegetation treatment standards. So for the time being, starting tomorrow, any ADUs have to meet those rules, but at some point in the future, likely to happen sometime in 2024, although we don't know exactly when, once the maps are formally adopted by the state, again, those new rules will only apply to those areas which are identified on the map as needing to meet additional wildfire hazard standards.
And then just to add to that, so that would be all structures at that point,
Correct, yes.
not just a house, or because the code reads the structures and its accessory structures. So all your structures on those mapped properties are going to have to include the fire hardening.
That's correct. So you can see in some ways the ADUs here being a little bit of a preview of what's coming for all development, all residential development, once those state wildfire rules are ultimately put online. Question is, has the Oregon Water Resources Department provided any information or what to anticipate for any exempt wells for properties that are requesting development of an ADU?
I'll touch on this, but Kyle, maybe you have more background too. So some of our local standards speak to how an exempt well can be used. So that's actually in the adopted code. So I can, if you're interested in those standards, let us know and we can point you to those. But I would definitely follow up with the Oregon Water Resources Department to get the information directly from them on any of the actual limitations on how that is used. Do you have any other background?
Yeah, I can add a little bit more here. So one thing that's important to keep in mind is the construction of an ADU does not qualify a property for another exempt well use on site. So if you are planning on constructing an ADU, your exempt water use limit, groundwater use limit applies to both your primary dwelling as well as the ADU. So all of your water use has to fit under that standard under OWRD's rules. We as Deschutes County do not specifically review those, but we would refer you to the Water Resources Department if you have additional questions regarding that. I think we've talked a little bit about this, but maybe it's helpful to reiterate here at the end. What is defined as usable area? Is it net interior space or the gross footprint or something else?
So we're going to take the whole footprint. We're not going to subtract walls or cabinets or anything like that. The only thing that would not be counted is if you have a staircase leading to a second story, that's only going to be counted on one floor calculation. Otherwise, everything within the footprint that's not a garage, deck, or porch goes towards that calculation. So no taking out siding or anything like that to get under that 900 feet. We're just counting the whole footprint.
Awesome. This is a good question that I know has come up quite a lot. Is there any type of amnesty process anticipated for existing non-permitted ADUs?
Oh, code enforcement.
Go for it, Angie.
Yeah. So we are pro education. We want you to come ask us these questions. If we see a safety issue, that we are required to address that at the time. But really, we do want you to come to us, ask us questions. We're pro education. Ask us for pre-app meetings for conversions of these units that were built previously. I don't know about amnesty, but yeah, come talk to us. We're glad to help.
Yeah, I would say generally, if you have some type of pre-existing structure that again meets all these standards and you want to convert that into an ADU, we've talked about it a lot here tonight, but that is available to you. And that would be certainly the direction we want you to go to make sure everything's safe, up to code.
I would say a caveat to that is if we're seeing something, dangerous egress issues, people sleeping in spaces that they're not able to get out for fires. Second stories without decks, railings, some sewage, illegal sewage disposal. I mean, those are public health and safety issues that we would be required to work with you on. So caveat to that.
And I'll add too, if you have an ADU that's been around since, I don't know, the 60s, come talk to us, or older, that would be a different use category. But anything built, in the last 40 years, we would want to go through the pre-app process to see if you can qualify for the current ADU allowances. And Kyle, I think we have time for one more question.
Yeah, we'll end on maybe a tricky one. What if there is a discrepancy between my property's dial lot size and a survey on record?
So just as a general rule of thumb, when we're trying to determine how large your property is, we're going to rely on the dial acreage. That isn't always accurate. So if you present us with more detailed information, like a survey prepared by a licensed surveyor, or in some instances, tax lots, for example, a river, they don't actually have assessment to the center line of the river, but the platted lot continues further out. And so you actually get additional acreage. So we'll either, accept a survey, if there's a subdivision plat that shows a larger acreage size. This is something that is new. So at least those two things are things that we're confident that we would be able to accept to show that you meet that 2 acre or 5 acre minimum. But, that's not to say there may not be other options as we see new information presented to us.
Not requiring a lot of record before applying for any of this?
We generally are. So yeah, that is in the code that lot of record review is required. Well, some properties are already platted as part of a subdivision or partition. So we have that in the record. And yeah, those records would tell us that's 2 acres.
I was just going to say thank you everyone for showing up tonight. A lot of great questions. Obviously we didn't get through all of them. I've got a whole list here. As I pointed out earlier, we will have staff available for a little bit of time here. If you have more specific questions, you want to come and talk to us, hopefully get everything ready, and note that everything's free and clear tomorrow morning. That is the earliest that our code comes online.
Yeah, we
Thanks.
do have planners in the back of the room. If you want to talk about the basic zoning standards, they're here and they can help have more handouts, application forms, that kind of thing.
So, thank you very much.